The attorney that was the first to file litigation against Illinois' gun and magazine ban in state courts that was transferred to federal courts, and now that case is up in the 7th Circuit Court of Appeals, has gone back to the Southern District of Illinois to request a partial judgment in favor of his plaintiffs to block Illinois' gun and magazine ban. Welcome back, Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk, and I want to thank each one of you out there, especially those of you in the intertubes, because I just surpassed 5,000 subscribers on YouTube ever since I've been covering the litigation in Illinois concerning the gun and magazine ban and the implications on the Second Amendment in this state, and doing the on-the-ground reporting, that drumbeat reporting of keeping you guys updated. I've just been blown away by the support and all of the likes and subscribes and all of that. So I appreciate that. Thank you so much. But let's get right down into this. I talked to Thomas Maag. He was the first to file in state court in Crawford County for his clients to challenge the state's gun and magazine ban. And you had the case being the first one. It was then transferred to federal court. But then you had 3 other cases filed in the Southern District, and all of those cases were lumped together in the Southern District and heard, and a Southern District federal judge, Stephen McGlynn, issued a preliminary injunction against the state. Didn't rule on the basis of the charges here. I think it's important to note. And Stephen McGlynn issuing that injunction, blocking the state from enforcing the law, but that only lasted for 6 days as the state went to the 7th Circuit Court of Appeals to stay, essentially reverse, that preliminary injunction. So after 6 days, the injunction was reversed, and now the case, those 4 Southern District cases, consolidated into the 7th Circuit Court of Appeals with cases out of the Northern Districts, where you had Northern District federal judges side with the state and local bans on guns and magazines. So all of those cases now in the 7th Circuit Court of Appeals, an expedited briefing schedule, and you've got a hearing that's set for June 29th. So all of that's going on. But Thomas Maag, he went back to McGlynn in the Southern District Federal Court and asked for a partial judgment on one particular challenge that Maag has in his case in the Southern District. I connected with Thomas Maag yesterday. He explained in some detail why he says that the law that's on the books right now banning certain magazines and certain firearms is unconstitutionally vague.
Well, it's very simple. It's on 2 parts, although we could have made it broader, but we focused on 2 parts. One being that the Illinois legislature, obviously having no actual knowledge of firearms, purported to enter a ban or enact a ban on, quote-unquote, all AR-style firearms and, quote-unquote, all AK-style firearms. There is no objective way to determine just what that means. Anybody that does know anything about firearms knows that AR stands for Armalite. There are dozens of different Armalite models, at least 24 that I'm aware of. Many of them were prototypes, but for instance, does that ban the .22 rifle, the AR-7? It's an AR-style rifle because it says so right on the gun. It says AR-7. Does it ban the AR-24 pistol, which is a CZ-75 clone? It says AR-24 right on the pistol itself. And even the examples they give don't help. The legislature has defined a Mini 14 tactical rifle as a, quote, AR-style rifle, which it's not. It's a Garanda-based rifle. Or they've defined the Beretta AR-70 as an AR-style rifle, which has nothing whatsoever to do with what presumably they're referring to the AR-15. The same goes with the AK-style rifle. They define SKS with detachable magazine as an AK-style rifle. Well, it's not. It uses a G43/7 Simonov gas action as opposed to the Garand-style gas action in a Kalashnikov. These people in the legislature have no idea what they're writing about, and there's no objective way to determine what is banned. The same goes true with magazines. The bill purports to ban handgun magazines of over 15 rounds and rifle and shotgun magazines of over 10 rounds, but there are many rifles that use handgun magazines that will fit in handguns and vice versa. There are firearms common on the market that are neither rifles, pistols, nor handguns as defined. What about those? There's no objective criteria to determine what is legal and what is not, which is why 20, 30 years ago, the U.S. Court of Appeals for the Sixth Circuit declared a nearly identical ban unconstitutional in Springfield Armory versus City of Columbus. It is so vague, it is undecipherable.
So Maag, again, he went to the Southern District's federal judge, Stephen McGlynn, and he asked for a partial summary judgment. What exactly does that mean?
In plain English, we're moving for summary judgment on the one count in the complaint that raises the vagueness issue. It would be dispositive of the whole case, but only on that particular issue, as opposed to a summary judgment motion where each count is briefed.
So Maag looking for just the issue of vagueness to be the reason why this could be struck down. If it is struck down by Stephen McGlynn, federal judge from the Southern District, what would that mean for gun owners across the state?
It would mean most likely that the judge, if he granted the motion, would do what the U.S. Court of Appeals did in Springfield Armory versus City of Columbus and strike the entire ban in the entire state of Illinois. The Attorney General's office, at least thus far, has taken the position that either the whole ban stands or the whole ban falls. And so if it's unconstitutionally vague as alleged, the whole ban should fall.
So again, sharing with you a conversation I had with Thomas Maag, who requested the Southern District rule on a partial judgment that the gun and magazine ban is unconstitutionally vague. What does this mean for the Seventh Circuit Court of Appeals case that's currently pending with an expedited hearing scheduled June 29th when they're going to hear that? Maag says it could go several different ways.
What's in the Seventh Circuit deals only with Second Amendment issues as opposed to due process vagueness issues. And what's in the Seventh Circuit also only deals with preliminary injunctions. There's a couple of scenarios. If the judge denies the motion, obviously the appeal proceeds. If the judge grants the motion for summary judgment on vagueness grounds, depending on whether or not the state appealed that, it may render what's in the Seventh Circuit now moot. It may not. There's a lot of options there, depending on the exact ruling from the court and exactly what the state chooses to do with it.
So if the state chooses to appeal a Southern District partial judgment blocking the law from being in effect, we'll see how that plays out. What's the timing here? When can we expect something? Here's Thomas Maag.
Judge McGlynn entered an order giving the state, by my reading, until Monday to respond to the motion. The state had asked for a general stay on briefing that motion. That tells me that the judge is inclined to probably consider it sooner rather than later. But that's just a guess, trying to read the tea leaves.
So Thomas Maag, conversation I had with him yesterday afternoon, talking about him requesting partial judgment against the gun and magazine ban from federal judge Stephen McGlynn, while the case is already up in the Seventh Circuit Court of Appeals, but it's not on the grounds of the challenge, right? It's about a preliminary injunction that was issued and denials of preliminary injunctions from the Northern District. So Maag going to the Southern District, attempting to get that partial judgment against the law, which could strike the entire law down. So I will share more from what I got from Attorney Maag about the measure that blocks citizens' ability to file lawsuits in their county courts. We'll share that just as we talk with Thomas DeVore live after 7:30. So much more to come from Thomas Maag. So stay